Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for joining us for this post-argument episode of SCOTUScast. I'm your host, Spencer Karen. On March 31st, 2021, the Supreme Court heard oral argument in National Collegiate Athletic Association, NCAA, versus Alston. The question before the court was whether the U.S. Court of Appeals for the Ninth Circuit erroneously held, in conflict with decisions of other circuits and general antitrust principles, that the NCAA's eligibility rules regarding compensation of student athletes violate federal antitrust law. The Honorable Joshua D. Wright, Professor and Executive Director of the Global Antitrust Institute at Antonin Scalia Law School of George Mason University, joins us today to discuss this case's oral argument.
Alston is a case about NCAA member imposed restraints on what they describe as education-related benefits, right? So it's a challenge. Bannon had name, image, and likeness rights. This is about restraints imposed by the NCAA on education-related benefits. How much they spend on things that they define as education-related benefits. The court talks a lot about computer equipment and books and things. And that distinction I sort of lay out in the beginning because for those of you who listen to the oral argument, there is a sort of battle over competing parades of horribles for what happens if Alston wins, what happens if the NCAA wins. Do we get into sort of pay for play and all out compensation wars for student athletes between member schools? They're sort of dancing around the line of what the decision would mean in either direction for the college athletic system generally. Like, do we end up in pay for play overall? Is that good? Is that bad? Et cetera. So one might listen to the argument and think those those restraints were at issue. They are not. They're sort of a narrower set. A point that Alston's counsel made repeatedly, and I think fairly effectively throughout the oral argument. So at the district court, the court found that there might be some limited pro-competitive justification for some of the challenge restraints to the extent that they were able to preserve, able to facilitate differentiation between college sports and pro sports by preventing unlimited payments that were unrelated to education, right? So the district court sort of opens this window to the idea that some of these restraints might actually be pro-competitive, that there actually may be some pro-competitive differentiating features of restraints that communicate to the marketplace that this product, college sports, is different than the alternative in the pros. But the court goes on and finds that the student athletes had successfully proven that there were less restrictive means of accomplishing those ends than the restraints actually adopted by the NCAA and rules for the plaintiffs. As a remedy, and I think there's lots of discussion of the remedy in the oral argument, and I think it is an odd one, and for the antitrust lawyers on the call, they will certainly find it to be odd, and I think you saw some back and forth with the lawyers and the justices in a conversation of what to make of the remedy. But as a remedy, the district court enjoined the NCAA from maintaining rules that cap education-related benefits, but otherwise sort of leaving the NCAA to do its own thing. The injunction from the district court allows the NCAA to write its own rules on what related to education means. It allows the individual conferences to sort of sets the floor, but it allows individual conferences to sort of compete on the dimension of what education-related benefits means and impose their own more stringent caps. In doing so, it's the NCAA sort of chooses a number, and the number comes from sort of somewhere in the record on valuation, sort of traditionally given to student athlete for educationally related expenses, sort of somewhere, I think it's $5,900 something, right? So about $6,000. And so that number sort of entered into the injunction. So bracket there for a moment. This should make the hair on the back of the neck of the antitrust lawyers listening in stand up a little bit. The underlying ruling says the NCAA, so Section 1 Sherman Act case, right? So I need an agreement between competitors. I've got that. We need to find that the agreement is in restraint of trade, that it is anti-competitive. And the court says an agreement to set education-related benefits is unlawful under Section 1 of the Sherman Act, but the remedy is the setting of exactly the same. That is an odd sort of remedy in antitrust. And that struggle, I think, comes from, if you listen to the argument, you see, Justice Breyer strikes out in particular in my mind at the moment. You see some struggling with what happens in a world with no injunction at all here, or no limits, rather, on NCAA ability to impose sort of limits on compensation. If schools, conferences, where it had the unfettered ability to compete, then sort of where do we land? For folks with an antitrust background listening in, unfettered ability to compete is sort of what we do. It's what we aim for with an injunction in an antitrust case where the plaintiff has successfully demonstrated that the restraint at issue indeed violates the antitrust law. The goal of the injunction is to sort of restore the competitive outcome. It is in that light that you find the sort of injunction here, an odd antitrust animal. And I think if you listen into the oral argument on your own, or if you've done so, you see lots of sort of struggling around with what to do. I believe it was Justice Sotomayor who at some point says, well, isn't this just judicial price fixing? And Jeff Kessler responds to the question, I believe, saying, no, the NCAA picked that number. Well, the court issued the order, and the order sort of specifies a number, and sort of antitrust law, Section 1 antitrust law sort of 101 is no defense of a Section 1 case to say that horizontal competitors have selected a reasonable price. That's not what we do in antitrust law. We force, rather than cooperating together to suppress competition, we force those institutions to compete. And that's sort of not what the remedy does. And so you've got some issues that arise in oral argument, and I'll return to those, but I just sort of wanted to highlight a little bit the remedy. Ninth Circuit reviews the trial record and unanimously affirms the district court's finding and its injunction. It concludes, and sort of the second step of the rule of reason framework says at step 1, the student athletes have successfully satisfied the initial burden of showing an anti-competitive effect. No surprise that sort of NCAA sort of proudly says we've defined our product to suppress wages. And in step 2, says the district court did just fine, right? it credited the NCAA's argument that some restraints are necessary to facilitate demand for what the NCAA at least describes as this differentiated product. It says, sure, if true, and you have imposed restraints that facilitate demand, if factually true, that's okay. You can make those arguments. Those are cognizable arguments under the antitrust law. You've got to prove them up factually, and you have for some, you haven't for others. And so it sort of says at step 2, some of the challenge rules serve a pro-competitive purpose, but the limits on non-cash education-related benefits do not. Okay, so we end up in that setting, sort of coming to the Supreme Court and the oral arguments, which were one of my favorites to listen to out of the sort of recent set, because I think you've got, as sometimes happens in the sports cases, you get, sports antitrust is sometimes a different animal, and occasionally you get, unique tensions between the ways people feel about markets and products and sort of how they run into Section 1 doctrine. And I think you see a little bit of that here. Let me give a couple of my own observations about what I heard and how I sort of see the case and see things in light of the oral argument, and highlight a couple of things that I thought were interesting. So I view the case largely, and I think both sides in the oral argument sort of embrace this view, at least in parts, although they may characterize it differently, as about the boundaries of the limits of antitrust law in reaching product design decisions for firms. This is a big, important area of antitrust law, and somebody described, I'm forgetting which justice described, I believe it was Waxman. So it said, well, the received antitrust wisdom is courts don't second guess and Monday morning quarterback. I guess that's not college sports, but Monday morning quarterback product design decisions. We review restraints after the fact. We maybe even review mergers after the fact, but we don't do that with product design decisions. That's sort of a special place in antitrust law, and it's true. I can cite you cases sort of from now until the end of the call where courts have said, hey, product design is special, and we really don't want Article III courts micromanaging and second-guessing product design decisions. And the NCAA grasps on to that concept in those cases and structures its defense around it, right? That is a principle that exists somewhere in antitrust doctrine, and they grab onto it and they say, sort of primarily as their defense, we have made what we pay our workers a feature of product design. Now, here's where I think you get into what I view as the primary problem for the NCAA's argument, and the primary flaw in the NCAA's argument, which ultimately I think will lead it to lose here. And we can have fun talking about vote counts later, but I think they lose here for the following reason. Let me sort of break this into two different observations and tie them to the oral argument. One of the observations is that the place where that product design principle lives in antitrust law are largely Section 2 cases. They're largely monopolization cases. There are cases about what a single firm does to design its product. It is really difficult to win an antitrust case alleging that a single firm, even one with monopoly power, has designed the way in a product in a way that you don't like, right? So, you'll see this with respect to, there were investigations. The FTC closed investigations in Google search back in 2015. There are about, the order of search results, right? There is a robust, long-standing principle that a single firm gets to design the product the way it wants. If it doesn't want it to be interoperable, if it doesn't want it, if they don't want to sell to a rival, right? Refusal to deal law. Within the bounds of antitrust law, plaintiffs can win, right? But it is rather difficult, and courts are sort of reluctant to redesign the product and say, hey, listen, a firm that has been successful, with a product for which there is consumer demand, let's sort of second guess and go in and say you should have designed it differently. Problem is, this is not a monopolization case. This is a case where instead the NCAA finds itself not making an argument like Google and search. We design the product the way we like. The argument they are making is that they got together with the NCAA as a collection of competitors that got together and said, we are going to make a product for which the core feature is an agreement between rivals to suppress wages below the competitive level, right? That I think is different in kind, not just degree, from the type of product design cases from which the sort of deferential principle in antitrust law was birthed. It is quite different. And what they've done is they've said the core product design feature of amateurism is not just low wages. It is an agreement between competitors, an agreement that would otherwise be a Section 1 violation, and Jeff Kessler leads with this point. He says, any other context, this would be a per se antitrust violation, maybe a felony, right? Maybe pursued criminally. Okay? But it's been treated here historically for different reasons, and so look, we'll sort of live with the rule of reason, but let's not make any qualms about the fact that this is an agreement between rivals that otherwise would probably be per se unlawful.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.